to our school, Professor Akhil Amar. He was here to deliver the Harris Lecture, what I had in mind as about 4 years ago, but in fact it was a decade ago. We're very happy to have you back. We do not have a lot of Professor Amar's time this afternoon, so I am going to dispense with his indulgence with the usual 3-page introduction of his life and achievements and be brief. He is the Sterling Professor of Law and Political Science at Yale University, where he has taught since 1985, and is one of the country's leading scholars of constitutional law. He is the co-author of a leading case book in that area, the author of several extremely influential books in that field, and is also a frequent commentator in the national media on issues of on important constitutional and policy issues. So today he is going to talk about his new book, which is entitled America's Unwritten Constitution, The Precedents and Principles We Live By. Before I turn the proceedings over to Professor Amar, I do want to acknowledge our student chapter of the American Constitution Society. So the ACS was founded in 2001, and over the past decade has acquired now 190 law school chapters. And that student network of chapters really plays an important role in the Society's mission to shape debate on key issues of law and public policy within our democracy. Our chapter, which is headed this year by Jim Spangler, has been working very hard to develop programs and events of interest for the school, including the recent voter ID panel on Constitution Day. So I just wanted to say thank you to the chapter for the work that it is doing and for proposing and organizing this particular event. So with that, please join me in welcoming Professor Akhil Amar.
It really is such a great treat to be back here. And most of you all are pretty young, and you may not have fully appreciated this thing about memory that us old folks appreciate. And Proust writes about it, how you come back to a place where you haven't been for a long time, and all sorts of memories come flooding back. Memory is very geographic. I have extremely fond memories of this room in particular, because you all were so generous to me the last time I was in this room. And I see my friend Don Johnson here, and we go back probably longer than either of us wants to admit. And so there are just amazing memories that I have of this place, and I just wanted to thank you all at Indiana and the ACS in particular and Don as the advisor, Jim Spangler for inviting me back. It really means a great deal to me. And I'm sorry I'm going to have to literally eat and run, but thanks for coming. Now, I have basically a huge favor to ask of you all. I'm really delighted that so many of you actually have this book in hand, and I'm going to actually, the huge favor is, I'd love it for you to actually read it. Because it doesn't mean anything at all. My publisher wants people to buy it. I don't tell my publisher, but I actually don't care whether people buy it or not. And actually, the real cost of the book is not the Amazon price. It's that I'm asking for a lot of your time. That's the real cost of you. You actually have to engage this stuff. And what I'm going to try to tell you today, really try to make the pitch why it's worth it for you to engage this stuff, because actually I tried to write a book that would empower you, empower us all. Try to write a book that would actually try to explain how to make constitutional arguments, how to make persuasive and successful constitutional arguments, sometimes even to people that might vote against us on election day, but whom we can persuade when we really do have the better legal argument that they should vote with us. And we can't do that without tools. And this book is basically trying to really empower you, equip you to have the kind of tools I think you need to be 21st century constitutional lawyers. When I'm in front of other audiences, I don't quite make the constitutional lawyer pitch. I make the even broader claim that ordinary citizens need to actually understand the Constitution. The thing is, actually, I have to bring out my ACS version. I'm using the wrong copy of the thing. So here's the approved version, the ACS version. It's short for a reason, so that ordinary people 225 years ago could read the thing and decide whether they were for it or against it. And today, the ordinary citizens can actually read it and decide whether it should be amended or not, and whether they agree with its principles. So to be a citizen in the 21st century, I think you actually have to engage the Constitution. The problem, one trick is, it turns out that there's more to the Constitution than just the 8,000 words in this text, which will take you about half an hour. This text doesn't say separation of powers in so many words, or checks and balances, or the rule of law. It doesn't say limited government, or federalism. It doesn't say the Bill of Rights. There's a portion that we call the Bill of Rights, but you won't find that phrase in the document. You will in various state constitutions. Doesn't say separate is inherently unequal. Doesn't say one person, one vote. Doesn't say the right of privacy. Doesn't say presumption of innocence or proof beyond reasonable doubt. Doesn't say that a criminal defendant has a right to take the stand in his own behalf. And, let me take that one in particular, when the Constitution was adopted, no criminal defendant could take the stand in his own behalf. None. In any state court, not in the federal courts. And at the time the 14th Amendment was adopted, almost no criminal defendant could take the stand in his own behalf. He could in Maine, maybe a couple other states, but not in the federal courts, not in most state courts. And today, every criminal defendant has a right to take the stand in his own behalf. And every Supreme Court justice believes that, left, right, and center. Justice Alito's maiden opinion for the court presupposes the right of a criminal, he's a former prosecutor, the right of a criminal defendant to take the stand in his own behalf. So you know what I just proved? I've just proved that we are all living constitutionalists. And by the way, we are all textualists too. Because those of us who are, who believe that new rights emerge want to point out that the Ninth Amendment says textually that there are rights that might not be enumerated, but that nevertheless should not be denied or disparaged, disrespected. The text says no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. So states can't have laws that violate basic rights, freedoms, privileges, or immunities, but the text doesn't tell us what those rights are comprehensively. It doesn't even tell us where to find all of those rights, or unenumerated rights of the people, for that matter. But the text itself gestures beyond itself. The text itself invites certain forms of interpretation that go beyond mere textualism. The text itself says that punishments can't be cruel and unusual. And certain punishments may have always been cruel, but they were usual way back when, and they're not usual today. And that's living constitutionalism, authorized by the text of the Constitution. We are all textualists. We are all living constitutionalists. Can't we all just get along? That's actually the deep claim of this new book, that the culture wars and the sound bites notwithstanding, we actually have more in common as a constitutional culture and as a society than we understand. And once you understand that, rather than just writing off all the folks on the other side because you think they're different from you, you may have some possibilities to persuade people of legal common ground, because you are lawyers. You will be lawyers. So that's what this book is all about, trying to be neither left nor right, red nor blue, liberal nor conservative, but to try to identify the tools and techniques that go beyond plain meaning that still are actually properly playing the game of American constitutionalism. Because I don't want an unwritten constitutionalism in which people can just make up stuff. I don't want this court to feel free to make up stuff. 5 justices on this court left to their own devices, if they're free to just make up stuff, might make up a lot of stuff that I don't want and that actually would do violence to this terse text. I know I'm bringing out the other copy here, but you see, it's neither red nor blue nor green. It's our common inheritance, and so this is a book that tries to show you all sorts of things that are beneath the Constitution and behind it and beyond it that are still faithful to it. Unwritten constitutionalism that doesn't lose all the virtues of written constitutionalism. That's the challenge of the book. To try to persuade you that there are ways of doing constitutional law faithfully that aren't pure literalism. The last book I wrote, America's Constitution, a Biography, took the reader through the written text from start to finish, from the preamble through Articles 1, 2, 3, to the end of the original Constitution, and then through the amendments, which happily are added in in chronological order. And so we move sort of through time forward from the founding and the Bill of Rights, the Civil War amendments, 13th, 14th, and 15th, the Progressive Era amendments, the Income Tax Amendment, the direct election of senators, and franchise of women, the modern amendments of the 1960s, ending poll tax disfranchisement, giving 18-year-olds the right to vote. And by the way, there's a liberal trajectory here. The amendments have virtually always added to liberty and equality and not taken it away, except for the ill-fated experience of prohibition. I just gave you now a huge argument for why certain kind of amendments would be wrong, because they actually go against that trend and trajectory, and other amendments actually would be right because they would extend liberty and equality. I just gave you a conservative argument for substantively liberal amendments of a certain sort. That certain kind of amendments, saying same-sex marriage is constitutionally prohibited, that would be a really unprecedented amendment. That would not fit the trajectory of the amendments thus far. In a way that an amendment that said people born outside the United States who have been here for many years and contributed to the society, naturalized citizens, should be eligible for president, that actually would fit the trajectory in a way that an anti-flag burning amendment or an anti-gay rights amendment wouldn't. Okay. So the last book took you through the text from the beginning to the end. But I ended that book by saying there's so much to our constitutional tradition, as I just began this talk, that goes beyond the text. The challenge of this book is, how do you organize that? I mean, what is the unwritten Constitution? It could, it's like capturing lightning in a bottle. It seems very hard to get our hands around. I eventually came to the recognition that this book had to be organized around tools and techniques of interpretation. Here's what the written Constitution doesn't tell you. It doesn't tell you explicitly and comprehensively how to interpret it. The rules of construing the Constitution itself are to some extent unwritten. And actually, plain meaning of words isn't the whole story. I'm going to show you that in just a minute or two. So once we go beyond plain meaning words, because you could say, well, the rules are the rules of the English language, Amar. Well, not quite. This is not just the English language. This is law. This is constitutional law. And there's special rules of law and constitutional law interpretation. And I'm going to write a book showing you the tools and techniques, the rules of interpretation beyond plain meaning that enrich our understanding of constitutionalism. So each chapter shows you a different way of going beyond the Constitution and yet still playing the game. So, first chapter, and I'm basically going to give you an overview of the whole book because my job today is basically to entice you to actually read it, to spend some time, and I have to persuade you that it's worth your while. Chapter 1, you have to read the text as a whole rather than word by word, sentence by sentence. So someone could say, okay, Amar, we get the idea that there's federalism and separation of powers and checks and balances and limited government. That's fine. Everyone buys that. I say, fine, but here's a far edgier point. Sometimes the Constitution properly understood, properly construed, means the exact opposite of what the literal words seem to mean. If I can prove that, this is like, you know, a magician sawing a lady in half. You know, this is a cool trick. And so watch carefully. Nothing up my sleeve. Simple question. This book is filled with examples because I think you understand rules and techniques in a lawyerly way with actually cases and controversies and hypotheticals and factual situations. Simple question. Who presides at the vice president's impeachment trial? I hear a few giggles because it is actually for a con law insider. This is a great joke. You know, you already know the punchline. So, what does the text say? The text very clearly says who tries impeachments. Which body tries impeachments? The Senate of the United States. The Constitution also says very clearly who is the presiding officer of the Senate. Joe Biden, the Vice President of the United States, is the Constitution. So, if we read just by plain meaning, as 2 + 2 = 4, the Vice President presides at his own impeachment. And now the rest of you are starting to get, because you know that cannot be right. And you know that whether you're a liberal or conservative or Republican or a Democrat, East Coast or West Coast person, because you actually have legal instincts and sensibilities, and you understand that can't be right, and it isn't right. But you won't see that just from the seeming plain meaning of the words. And then I show you how actually we actually deduce this from the Constitution, rightly read. And we could, I think the deepest idea, well, let me take, it turns out there are 2 exceptions to the general proposition. The problem is textually they don't seem to apply. One exception, who presides when the president is impeached? Bill Rehnquist when Bill Clinton was impeached, right, the Chief Justice. But here, of course, it's the Vice President who's impeached, so that textual exception by its terms doesn't apply. And what happens when the Vice President isn't around, when the Vice President is absent? Who presides? And he usually is absent. So the Vice President usually doesn't preside except ceremonially or where there's going to be a tie, they expect a tie vote on something. It's the President pro tem of the Senate. So there are 2 exceptions, but neither of them applies textually on its own terms. The Vice President is saying, I'm not absent, I'm right here. You know, I'd like the gavel, please. You know, you're trying me. And the President isn't being impeached in my hypothetical. My question is the Vice President. So if we're just doing plain English, you know, the words seem to very clearly apply. There are a couple of exceptions. They're clearly not applicable. By expressio unius, we'd say, well, you know, the exceptions don't apply. But we don't say that. Now, here's one reason we might not. Why does the Chief Justice preside? The text does not tell you in so many words. You actually have to go beyond the text. But why does the Chief Justice preside? When the President is being impeached.
He's biased.
Because the Vice President shouldn't. Because he wouldn't be impartial. Because not because he's the running mate, but because in the founding, he's the runner-up. He's the guy who ran against the president and lost. He's Thomas Jefferson to President John Adams, and that would not be impartial. A man, he would have too much to gain. Well, if he can't preside when he has the presidency to gain, of course he can't preside when he has, his office to lose either. It follows off, because maybe you needed the vice presidential, so the Chief Justice Clause is actually the vice presidential recusal clause. And they specified it for the president because maybe you needed to, because strictly speaking, the vice president wouldn't be presiding over his own case, but someone else's. But of course, it's obvious and elemental, it goes without saying, no man can be a judge in his own case. That's what the rule of law actually involves, and the Constitution is law. So even if we didn't have that clause, he couldn't preside in his own case. But maybe you needed that clause, because strictly speaking, when the president is being tried, the vice president isn't presiding over his own case, but someone else's, so you needed that clause, maybe. But the idea that you should say, well, but it doesn't say that he can't preside over his own case, that'd be like saying, well, you can't try a guy twice for the same criminal offense, but 3 times, what the hell? It follows a fortiori from the sentence when you understand its purposes, but this is not literalism. It's not expressio unius. And I would think that even if the Chief Justice Clause didn't exist, Because deep down, I would think that because of the rule of law, and the Constitution is law, and there are certain premises and presuppositions, and that's one example. I start the book, actually, by telling you the very first opening minutes of the impeachment trial of Andrew Johnson. And here's what happens. So who's presiding? Who's being tried? The president. So who would be presiding? The Chief Justice, Simon P. Chase. And the senators are coming forth one by one to being sworn in. And then there's the moment that everyone waits for. The senator from Indiana jumps up. Yes, from Indiana, Thomas Hendricks, and objects to the imminent swearing in of I love this other guy's name, Senator Benjamin Franklin Wade. And Benjamin Franklin Wade is about to take the oath, and Senator from Indiana rises up and says, I object. And why does he object? He objects because Benjamin Franklin Wade is president pro tem of the Senate and is therefore, under the existing rules at the time of presidential succession, next in line for the presidency. And so how can he fairly sit in judgment of Andrew Johnson when he will move into the White House if Johnson is guilty? And then John Sherman steps up, the younger brother of William Tecumseh Sherman, who's every bit as fierce as General Sherman, his brother. He says, what are you talking about? Ohio is a state. We're entitled to 2 senators. This guy is the senior senator. I'm the junior senator. You can't, cut Ohio's portion in half this way. And the game is afoot. These great constitutional lawyers going back and forth on this question, and I won't tell you how it turns out, because I want you to at least dip into the book. But that's Act 1, Scene 1. And what they're talking about is whether a person can be a judge in his own case, and if not generally, were there any unwritten exceptions to that unwritten principle? And it turns out there are some unwritten exceptions to that unwritten principle, like a thing called the rule of necessity. And I won't tell you what that is, but you'll just have to find out for yourself. So that's Act 1, Scene 1. And the Constitution originally doesn't say the freedom of speech, but it does say that the people are sovereign. And how can the people be sovereign if they can't politically express themselves? And it says government agents, servants are our agents. They work for us. And how would that be true if they can tell us what to say and not say? It'd be like your butler telling you what you can say at your own dinner table. And it does say free elections. And how can elections every 2 years and 4 years and 6 years, how could those elections really be free if insiders, incumbents, could criminalize the speech of outsiders? This is what Alexander Meiklejohn understood, Charles Black, even Robert Burke on the right, that even without the First Amendment, free speech is implicit in the structure of the thing as a whole. So even though the First Amendment says Congress can't abridge speech, well, why should federal courts be allowed to abridge free speech, or the president be allowed to abridge free speech, or states to be allowed to abridge free speech? And this is true of the structure of the document as a whole. So this chapter is not actually that edgy. Charles Black taught us long ago that structural interpretation is an important method, and it goes beyond clauses. I think I give some fun and interesting examples of where that's so. And by the way, John Marshall, what clause did he rely on? Because there's no bank clause of the Constitution. And you're all taught he relied on the necessary and proper clause. He didn't, because he's not a clause literalist guy. He actually relied on the Constitution as a whole and its structural implications to uphold the power of Congress to create a bank, which is hugely relevant, should have been for the Obamacare case, and actually wasn't understood by the justices, because they actually think, Justice Scalia actually thinks, he said so in earlier cases, that McCulloch is based on the necessary and proper clause affirmatively, and actually isn't. It's based on the structure of the Constitution as a whole. And so there's not this debate, is it the Commerce Clause, is it the tax power? Okay, so that's Chapter 1. Chapter 2, different technique altogether. Forget the text as a whole. Don't read it. Look at what the Constitution actually did. The Constitution isn't just a text, it's a deed, it's an ordainment, and it's establishment. An act of ordainment is a constituting. It's the most audaciously democratic deed up to that point in the history of planet Earth, because even though women didn't vote and some unproperty people didn't vote and slaves didn't vote, more people were allowed to vote on how they and their posterity would be governed in that year than had ever been allowed to vote for anything else in the history of the planet. It's really interesting and epic, and my claim is the Constitution isn't just the words, it's the deeds. The process by which the Constitution is adopted is itself part of the Unwritten Constitution. And there are principles in that process that we can actually identify, and those are constitutional principles. Here are 2. 1, free speech. Before the First Amendment comes along and textualizes free speech, we, the people, do free speech up and down the continent for a year. Some people are for the Constitution, some people are against it. They vigorously debate. The debate is, in a phrase, robust, uninhibited, and wide open. Some people burn Federalists in effigy, and some people burn Anti-Federalists in effigy, not in real life. In effigy, no one dies in the whole year. Compare 1776 or the French Revolution or Libya today or Egypt today. It's audacious. A whole year of the people fiercely, vigorously debating the Constitution. Free speech in action. That's how the Constitution was actually born. So I say free speech is part of the doing of the thing even before the First Amendment comes along. The First Amendment is a textualization. It says the freedom of speech as if it already exists. It did already exist. It's how we adopted the Constitution. Why does the Bill of Rights say 5 times the people? It says in the First Amendment, people right to petition and assemble, and the Second, and the Fourth, and the Ninth, and the 10th. Because it's coming from the people, from the preamble, free the people. It's coming from this popular process. The rights bubble up from the bottom. Constitution 1.0 is defective. It's crowdsourced by the people. It's like Wikipedia, up and down a continent. They basically say, dudes, you forgot the rights. And they insist as a condition basically of saying yes to 1.0 that we're going to modify it for 2.0. And some of the people who win in 2.0 in the Bill of Rights, they're kind of the dissenters the first time around. They're anti-federalists. They're people who aren't quite convinced. This is extraordinary to win in a way that keeps the losers on board, that says, you know, we hear what you're saying, next time you can be part of the process. It's amazing free speech in action. So forget the text and its logic. The actual doing was epic free speech. And by the way, what voting rule was used? The Constitution doesn't say. It says 9 states have to say yes, but it doesn't say what the rule is within New York or Pennsylvania or Connecticut or New Jersey. And the answer is simple majority rule. In New York, the vote is 30-27. Majority rule is built into the unwritten Constitution without saying so. The Constitution doesn't say that the 5 beat the 4 on the Supreme Court, but of course they do. It goes without saying. Now, I just gave you a huge argument for why today or tomorrow or any day 50 senators plus Joe Biden or whoever the vice president could get rid of the filibuster any day. And I explain that in greater detail because simple majority rule is a deep, abiding, inalienable, unwritten constitutional principle, part of the very process by which we adopted the Constitution, which was by majority rule in each and every state. And the dissenters didn't filibuster and immediately acquiesced. The 27, after they were allowed to say their piece, said to the 30, okay, you won. And now we move on. Let's have a Bill of Rights. Pretty extraordinary stuff. Not written, unwritten. How we actually do the thing. How did we do the amendments? Here's how we did the amendments. The 14th Amendment, in order, because some states had misbehaved, in order to get back into Congress, these states were singled out and they had to actually meet special standards before they were going to be allowed back into Congress. That's baked into the very process by which the 14th Amendment adopted. That's hugely relevant to whether Section 5 of the Voting Rights Act is properly allowed to single out certain states because they have bad histories for about voting rights performance, that they're singled out because they actually did the same sorts of things in micro that states had done that got themselves excluded from the Union during the Civil War. How the Constitution was adopted, how it was amended, is a huge source of principle. Okay, chapter 3. Forget about the text. Forget about the enactment history. Look at how ordinary people every day live their lives. This is a more chapter about Burke and custom and tradition. The Constitution doesn't say in so many words, do you have a right to wear a hat, or to have a pet dog, or to raise your kids, or to sit in your porch in your rocking chair, or to enjoy conjugal happiness consensually with your spouse. It doesn't say any of those things, but of course you have those rights because this is America. Ordinary Americans every day live out these rights. Ordinary Americans every day have supported state laws and state constitutional provisions recognizing a whole bunch of rights. Some of these have evolved. The right of a criminal defendant to take the stand in his own defense did not exist at the founding. It became very widespread, and when it did, federal courts say this is now a right of the people. This is now a privilege or an immunity of citizens because citizens claim these rights and believe they have them every day. So judges shouldn't look at just what other judges have said. If they're trying to figure out what our unenumerated rights of the people are, they have to look at what the people actually say and do. And look at what ordinary citizens actually claim in their daily lives are their privileges and immunities. And that's yet another argument for free speech. By the way, it's not just an argument for free speech, it's an argument for guns in homes. This is not just liberal stuff, okay? I say even if there weren't a Second Amendment, there's a long American tradition of having guns in homes for self-protection. Do I love it? Personally, no. Guns scare me. But this is not Amar's Constitution. It's America's unwritten Constitution. And if Griswold is right, because very few states actually criminalize consensual relations between spouses, then it's also right that very few places actually try to prevent you from having guns in your home for self-protection. And what's sauce for the liberals is sauce for the conservatives. That's, the liberals want sex in the home and conservatives want guns in the home. And I say, you both can have them. Personally, I think sex is better, but, maybe that's just me. So this is not liberal or conservative. These are neutral techniques of constitutional interpretation. The text as a whole, how the Constitution actually was adopted and amended, actual traditions and practices of ordinary people. A couple of chapters now on case law. Case law is written, of course. A lot of things are written, but they're not in the four corners of this document. And I try to show you how to think about case law as the lens through which we often read the text. We read it through the prism of the case law. And the question is, does that lens distort or does it clarify? And my claim is, in 1953, the case law was grossly distorting. It had diverged very far from the text. But thanks to Earl Warren and company today, actually case law is much closer to the text. And even though people don't understand this, the blogosphere and the culture wars still attack the Warren Court, actually what the Warren Court did, in fact, is generally accepted by conservatives as well as liberals. And I'll give you examples. How the cases originally diverged from the text, Warren and company brought them back together, and today actually that in general is common ground. With the one exception, I think the Warren Court got it wrong on the exclusionary rule. I think they went way too far, and I don't defend that. That's a conservative result that I have. And in fact, cases have been cutting back on the exclusionary rule. But apart from that, here was 1953. Here's the world of 1953. Widespread segregation and apartheid, and it's not equal, but courts allow it. Massive disfranchisement of African Americans in many parts of the country and violations of the right to vote, and massive malapportionment, and courts uphold it. Congress has tried to stifle free speech, political expression, and courts haven't done anything about it, and states have succeeded in stifling free speech. Organized prayers in the public schools where government is deciding, writing prayers on its own or picking whose denomination's prayers are going to be read, and courts uphold that. Criminal defendants have precious few few rights, and the Bill of Rights doesn't generally apply against the states. That's the world of 1953. That's not our world today, thanks to the Warren Court. The Warren Court says Brown versus Board of Education. And it's right because the Constitution really does say equal. And segregation really wasn't equal. Next case. That's it. The Bill of Rights really was supposed to be applied against the states by the framers of the 14th Amendment, and they didn't do that for a long time, and the Warren Court did it. And that's right. That actually brings the cases back into alignment. They're really supposed to be religious equality, and government picking which religions are favored, that's not equal, and they were right about that. It really does say free speech again and again and again. It does free speech, and the courts weren't enforcing it. And after Warren, New York Times versus Sullivan, they did. There are rights of criminal defense in the Constitution. Innocent people might be erroneously convicted, so it's important that you have a right to counsel even if you can't pay for it. And so the Warren Court's actually bringing the text into alignment with the case law. And this really is supposed to be a self-governing republic, and you can't have that if people are deprived of the right to vote, a phrase that appears 5 times now in our Constitution. 4 times during the Warren Court, and then another amendment added at the end of the Warren Court. And you can't have gross malapportionment and have basically Republican government that's fair. So what the Warren Court did actually brought the cases into alignment with the Constitution. And here's the kicker. Conservatives actually agree today. Even though you might not think that if you just read blogs or something, here's what conservatives said. We believe in Brown versus Board of Education, but that means the Constitution is colorblind and no affirmative action. Fine, but actually signing on to Brown. Liberals have a different reading of Brown. It's about integration and education. And conservatives say, no, it's colorblindness. They're all agreeing to Brown. This is progress, even though they have different interpretations. Conservatives say, well, we believe in one person, one vote. That means Bush versus Gore, because the Florida recount was uneven and unfair, and I happen to disagree, but they're actually signing on to Reynolds versus Sims and Harper and Kramer. We believe in incorporation of the Bill of Rights against the states, say conservatives. By the way, that means the Second Amendment too. If you're going to incorporate the First and the Fourth and the Fifth and the Sixth and the Eighth, well, that goes for the Second too. Guns and homes. We believe in religious equality, but you shouldn't be discriminating against religion in the name of an unduly strict separation of power. So conservatives, we believe in free speech. That means citizens united. Okay? They have accepted the Warren Court premises. They have different interpretations. The same guy who gives you Citizens United also says Congress can't shut down the Legal Services Corporation. On similar grounds, he's a free speech fanatic. He's a Warren Court groupie, and his name is Anthony Kennedy, and he's the swing justice. And you know who Anthony Kennedy is? He's a kid who grows up in Sacramento, California, when Earl Warren is governor of California and visits his house regularly, and he's a page in the California State Assembly. That's who Tony Kennedy is, and he's at least in some respects as close to Earl Warren, California Republican, as he is to Ronald Reagan, a California Republican. He's sort of generation. So the Warren Court rules today still. Different interpretations. There's a conservative reading of its case law and a liberal reading of its case law. But its case law is more in sync with the Constitution than you were taught and is more common ground than we've recognized. One big question is what to do when precedent really does diverge from the Constitution. And I talk about that in the related chapter. Because the Warren Court overruled a lot of precedents to get where it needed to go. So what should a lower court do if precedent is inconsistent with the lower court's understanding of the Constitution? What should a Supreme Court justice do? I have a chapter on that. Chapter 6. This is this Constitution. It's a symbolic document. It's what binds us together as Americans. It's our Queen Elizabeth, our Taj Mahal, our Eiffel Tower. But this isn't the only text that sort of defines the basic American creed. There are others of special iconic significance. I give 6 examples. I could have picked 16 easy ones. What else would you nominate for inclusion as a text that basically sums up what all Americans basically believe, what it means to be an American, the American creed? Declaration. That's one, and that's one of the ones on my list.
God Bless America? Like these songs? Like starts with a banner?
I don't have that, partly because the God Bless America is a little tricky. But many of the ones that I do have, like the Declaration of Independence, it mentions God very prominently, our Creator. We're created equal. The Supreme Judge of the universe is mentioned in the Declaration of Independence in the final paragraph, and they don't mean John Roberts. Federalist Papers is 2. 3. You've picked 3 of my 6. Suppose I were to pick something from the 20th century. I Have a Dream. I picked one case. You could pick 3, I think, plausibly. Roe versus Wade. Roe is not shared common ground. Because some people say it's the Emancipation Proclamation, and some people say it's Dred Scott. So it's not common ground in the way that Brown is common ground. It's huge, but that's why the following things don't count. Atlas Shrugged, or Grapes of Wrath, so because those are too partisan.
Griswold.
You could absolutely, Griswold is iconic today. I picked Brown, but what have we just proved? That we're all Americans. Because I've done this 20 places now. Every place I get the same answers. These are all videoed, or many of them. You can check it on YouTube. And every time I could look like an idiot because people could pose things that aren't on my list, and they never do. They always say the Declaration of Independence, and either the second inaugural, or the Emancipation Proclamation, or Gettysburg. I could have picked all of them, any of them, but all Lincoln all the time. But we are Americans. This is something we have. So here's, so yesterday, basically, the conservatives say Martin Luther King said we should be colorblind, judged by the content of our character, not the color of our skin. And the liberals say Martin Luther King believed in race consciousness, and what did he say in his last sentence? And God is here. He says he hoped for a day when all God's children, white men and black men, Protestants and Catholics, Jews and Gentiles, Protestants and Catholics, will join hands, integration, and sing in the words of the old Negro spiritual, free at last, thank God Almighty, we are free at last. There's a liberal reading of the I Have a Dream speech and a conservative reading of the I Have a Dream speech, but everyone claims King in a way that wasn't true when King spoke those words, wasn't true when Brown versus Board of Education came down, but this is actually progress. What progress looks like is we actually have a common. Lincoln used to be controversial in a way that he is much less so today, except for nut jobs. Okay. Chapter 7 is probably my favorite chapter. My friend Reva Siegel was here a couple of weeks ago. This chapter is kind of dedicated to her in a way. It's America's feminist constitution. How do we think about the fact that 200 years ago the women were excluded? And think about the radical implications of the 19th Amendment. Because once the 19th Amendment comes along, although it doesn't say so in so many words, it's really saying everything that happened before wasn't really fair. And what do we do with that? Look, when my 13-year-old, he wants to vote this election, and I say, sorry, you can't. And he's going to turn 18, and he's going to be able to, and he's going to, and I'm not going to, and he's going to say, but Dad, you didn't let me vote when I was, in 2012 when I wanted to. I say, yes, because you're now an adult, and you weren't then, and that's the right answer. We can't say that to women. Like, oh, you became smart in 1920, but in 1919 you were really idiots. And 1908 or 1866 or 1788. So the 19th Amendment, the Women's Suffrage Amendment, really has kind of radically destabilizing implications in a way. Where does it say that Sarah Palin can run for president, or Michelle Bachmann, or Geraldine Ferraro for vice president? It doesn't. And the Constitution in Article 2 says he, him, his. But the 19th Amendment, of course they have a right to run. And to be in the legislature, and to serve equally on juries, even though the text doesn't say so, and the Supreme Court didn't do that until 1975. The Supreme Court was wrong in not understanding the unwritten implications of the 19th Amendment. The 19th Amendment changes the entire nature of the presidency. Barack Obama has two running mates who could equally succeed him. One is named Joe Biden. The other is named Michelle Obama, who was also a Harvard Law grad. And by the way, it could be Hillary Clinton too, and that's not true. So he has two running mates. That's not true at the founding. Martha is not going to succeed George. Abigail, not John. Dolly, not James. It's a totally different world where women actually can succeed men. Women's suffrage, actually, women vote for the social welfare state. This election, the men are going to vote for Romney. And if Obama wins, he's going to win because he wins among the women. Women's suffrage gives you Franklin and Eleanor, Bill and Hillary, Barack and Michelle. It gives you the New Deal, the Great Society, and Obamacare. The justices on the Supreme Court voted 4-2 the men against Obamacare. It's the three women on the court who are the margin of victory for Obamacare. But maybe I shouldn't call it Obamacare. What should I call it?
Affordable Care.
Pelosi Care. after the first woman Speaker of the House, who was hugely responsible for the particular shape of that thing. This is the 19th Amendment. The Tea Party folks not only had their problems with the 16th Amendment, and they have real problems with the 17th Amendment, they are at odds with the 19th Amendment. 16 plus 17 plus 19 equals Great Society, New Deal, Obamacare. National progressive redistribution, 16th Amendment. U.S. senators who don't have to curry favor with state legislatures and so will vote for nationalist projects, 17th Amendment. And women's suffrage, they're going to vote for more social welfare stuff. That's maybe my favorite chapter, Chapter 7, Remembering the Ladies. It's a phrase from Abigail Adams. And it features a kind of fun little stylized dialogue in circa 1950 between two constitutional lawyers named Adam and Eve, who are basically Spencer Tracy and Kate Hepburn, if you've ever seen the movie Adam's Rib. Chapters 8, 9, and 10 are kind of a British constitutional perspective on our system. The British Constitution is unwritten, but they have a system of government. And I actually say, what does the world look like if we, how does constitutional law look if we understand that there are actually institutions that have emerged that do things? So Don was head of OLC, focusing a lot on what presidents do. My claim is a lot of what presidents do is dictated not by the text of Article 2, which isn't so specific, but by the practices, especially ones that began under the Washington administration. Over and over again, what presidents do, just the same way that Christians ask ourselves, what would Jesus do? Presidents ask themselves, what would George Washington do? What did George Washington do? Because if he did it, that often counts for more than what the text says. Does Obama get to fire the Secretary of the Treasury on day one if he wants? Yes, not because the text says so clearly, not because the Federalists say so clearly, but because George Washington established that in the thing called the Decision of 1789. Can Obama tomorrow recognize the Syrian rebels, as he did recognize the Libyan rebels? Yes, because Carter recognized the People's Republic of China, because George Washington recognized the French revolutionaries. And it goes back, can a president negotiate a treaty secretly behind the Senate's back? He's going to need to get their approval later on, but does he need to tell them before negotiating? No, because George Washington didn't. So on issue after issue, we read the terse text through a specific lens. The spectacles of George Washington. And other chapters talk about how we read other things by focus on actual practices of government. Where does the text say that Darrell Issa can hold Eric Holder in contempt? There's no contempt power in the Constitution. There's no oversight power in the Constitution. But from day one, Congress exercised these powers. And so I try to show you how stuff where governments try to do things that really doesn't plausibly fit with the text, it's repudiated. Legislative veto, independent councils. But where the text is ambiguous, often practices cohere with the text to give us specific solutions. And I try to show you how that's true in the presidency, how that's true in the House, the Senate, the independent agencies, how the two-party system has fit in with the Constitution. Okay, just to conclude, there's a chapter on the role of conscience in our system, what judges and juries should do if punishments are unconstitutionally savage. Can judges say, I'm not going to sign any death warrants? Can juries say, we acquit against the evidence? And that's unwritten, but I try to talk about the checks against an unduly savage criminal justice system in that chapter, and the abuses that could happen if juries refuse to convict in certain situations. So I try to give you both sides of that. And then here's the final chapter. The unwritten constitutional sense of the Constitution still to be written, the unfinished Constitution, the Constitution of 2020 or 2121, 2222. If we can look back 225 years or 150 years to the Emancipation Proclamation, it's 150 years ago this season, we should be able to look forward equally long and try to think what would be fair rules for us to bequeath to our posterity. What should the Constitution of the future look like? What amendments should we add and which ones shouldn't we add and why? And I try to give you some guidelines for thinking about that. I've gone a little bit over. We only have 10 minutes for questions, but I just really do want to say, look, 225 years ago, the Constitution actually gave the world more democracy than ever before. Democracy didn't exist on most of the planet 226 years ago, and now it exists over more than half the planet, and that's because of a project begun 225 years ago. And that project still continues, and it doesn't say, and we have to think forward This is your obligation as citizens, and you can't discharge that unless you have a sense of the past, you know the tools and techniques of interpretation. But your obligation to leave our posterity a better constitution than we inherited is not explicit. That obligation is not explicit in the written Constitution, but surely it is an indispensable element of America's unwritten Constitution. Thank you very much. Thank you so much. Get some questions, please.
I just wanted to say, for anyone who didn't get a copy of the book, they're for sale right here. They'll be
Oh, Jim, thank you. That wasn't a setup, but thank you.
The upcoming case of the Supreme Court.
Tommy.
Yes, about affirmative action.
Yes.
Do you feel like how do you feel like the outcome of that's going to be?
Oh, they're going to strike it down, and the question is just how broadly they strike it down. And at the extreme, they could say no government institution can ever take race into account, the race of an individual into account, and not just government institutions, private institutions too, because statutes have been construed to apply to schools that get government money, and that's all schools. That's Yale and Harvard and Dartmouth. Statutes have been applied to have been construed to apply the same rules that apply to University of Texas, University of Michigan, University of Indiana University to as a matter of constitutional mandate under the Equal Protection Clause. Those same rules apply statutorily under anti-discrimination law against private institutions, and that would lead to a massive resegregation of higher education in America. So I don't think that will happen, but that was what easily could happen if, for example, Mitt Romney were to be elected president and Ruth Bader Ginsburg were to step off the court for whatever reason. Not to mention Roe versus Wade.
Yeah, in chapter 1 you make...
So Dawn, did I get that right? Okay. I'm looking to Dawn here. She's my guide.
In chapter 1 you give some strong structuralist arguments for contextualize the Constitution.
Yes.
And then in chapter 2 you talk about the actual act of bringing it into force.
Correct.
But in doing that, you have the state constitutions where they were ratified by 2/3 and they had a 2/3 amendment process.
Yes.
It seems to me if you apply the structural argument to them, that there does seem to be something extra legal about that, or that you could make, the structuralist kind of taken as a whole holistic view that maybe that wasn't actually what should have happened.
I love the question. There are very interesting questions about why this ratification was legal given state constitutional law, some of which seem to suggest you needed a supermajority requirement. And I talk about that specific issue in Chapter 2, and the general sentiment prevailed in effect that there was an unwritten, inalienable right of a simple majority of the people to alter or abolish their government, and that's really interesting and edgy. And I come back to state constitutions in the last chapter because my claim is there's an intimate conversation between the 50 state constitutions and the federal constitution, and there are all these ways in which all the constitutions, state and federal, look very similar. Written constitutions, see, England doesn't have one, Israel doesn't have one. Separate bills of rights, judicially enforceable. Australia doesn't have that. England didn't have that. Bicameral legislature, well, that's not true in a bunch of societies around the world. A president who's elected independently of the legislature, and governors who look exactly like that. 4-year terms, veto pen, pardon pen. Governors look a lot like presidents rather than prime ministers. Single-member districts, 2 parties, the same 2 parties everywhere. Fixed terms of office. Politicians picking judges, juries, precedent. All of these are true of all, and these are not true around the world. They're not true in France. So we have a system, an American exceptionalist system of 51 constitutions, and the future reforms at the federal level are going to actually track things that states did first. So, for example, direct election of the president doesn't look weird. It looks kind of sensible because one person, one vote is a very big deal under the Warren Court, but wasn't before. And because that's how you pick the governor of Indiana, one person, one vote, direct election. That's how we do it in California too, and even in Texas, and in New York and Connecticut and everywhere else. You count all the votes, And if it's close, you recount them carefully. And if that's how we do it for the many presidents we call governors, that's why direct election of the president doesn't seem weird and foreign the way proportional representation or a multi-party system or other things would seem weird and foreign. So any weird and foreign idea might be better, but it's not going to take hold at the federal system unless states adopt it first, road test it, laboratories of constitutional experimentation, and show it can work here. And that began actually with some conversations about how state constitutions should be amended, which was part of the very process by which the U.S. Constitution was adopted.
I'll actually yield to Judge Hamilton, but I do have a question.
Okay, so I'll answer your question. Where's the good? Oh, there you are.
The Constitution includes a lot of prohibitions and rights.
Yes.
It doesn't say anything much that I can remember about remedies.
Yes.
And I was wondering if you could comment on Bivens and the implied right of damages.
Yes.
For damages. And
Yes. For statutes, it's tricky, but for the Constitution, I'm a pro-Bivens person. I wrote my first article as a law professor, sort of championing Bivens. Because the text is terse, it can't spell everything out, including remedies. The only even gesture in the direction of remedies in the entire document is a clause on habeas corpus. The Fourth Amendment was to be enforced originally not through the exclusionary rule, but through tort law. What law makes us secure in our persons, houses, papers, and effects? It's trespass law, property law. And so that deep structure of private redress was presupposed. And in the chapter on maybe the phrase that's near and dear to your heart, judicial power of Article 3, I spell out how that actually, it's very terse, but there are at least 5 things that are part of that. One is interpretation, saying what the law is. Second is actually implementation, creating doctrine, formulas, test rules for the use of the judges themselves and lower courts and litigants and general counsel to sort of understand how courts will operate. 3-part tests, balancing tests, and so on. So implementing, which is different than interpreting, actually making the thing operational, clear and present danger, all of New York Times rules about actual malice, strict scrutiny, narrow tailoring. So those aren't interpretation, those are implementation. That's doctrine. A third thing that I talk about is the remedy power, not just the power of right, but remedies. A fourth is the power to decide the case, the res judicata power, to be binding and conclusive, even if from a God's eye perspective, this would never be true of you, but someone else, where the judge gets it wrong. But even if the judge gets it wrong, it's still the law of the case, and because you had jurisdiction, the res judicata power, and then the stare decisis power, the power to establish precedents for your own courts and lower courts. All 5 of these are components of judicial power, and one of them is the remedial power, and I talk about that but it has to be a traditional remedy of a certain sort, or if not traditional, it has to fit the scope of the violation in a certain way. And I think Bivens does that, the exclusionary rule not so. That was very good of you to, remember her.
Hi, Judge Hamilton. Okay, my question is about substantive due process.
Yes.
Shift recently. It sort of was growing for most of its history, and then
Yes.
we had, Hamdi and then Anwar al-Awlaki.
Mm-hmm.
What's happening to substantive due process? Are we seeing a narrowing? Are we seeing it being?
Well, some of those cases are also partly about fair procedures and processes, but I myself don't like the label substantive due process because it seems made up. I prefer privileges or immunities of citizens because I want to reconnect the case law with the text so that when you read the thing, you actually say, oh, well, now I understand where these unenumerated rights come from. It says privileges and immunities. It says the Ninth Amendment. And you don't think it's all made up. What else might be an advantage of caulking? And my friend Clarence Thomas agrees with me about this. There are possibilities for crossing the partisan divide that we have to be attentive to long term. What are the advantages of calling it privileges and immunities rather than substantive due process? It's not made up. It's actually in the text, and there's a cultural advantage that ordinary people can be reconnected to the thing. Privileges and immunities tells judges to look at what ordinary citizens think and do. Substantive due process came from the courts themselves, and it tells courts to look at their own past precedents rather than to the society at large. I think they're better off learning from the citizenry rather than just reading, Lochner-era cases. Substantive due process is connected in the case law to the Lochner era, and it's about property, not just life and liberty, but property, and Dred Scott. If it's substantive due process, I don't see what role Congress has. And if it's privileges and immunities of citizens, Congress can help define and add to, it can't take away from, but it could identify certain things, the right of women to be free from violence or something, as a privilege or immunity of citizens. What it means to be a citizen is to be born equal. And if some people are born with 2 X chromosomes, and because of that, they're subject to certain sorts of threats, Congress has power to enforce the idea of equal citizenship, to identify privileges or immunities of citizenship. Healthcare could be understood as a Section 5 of the 14th Amendment idea that it's a basic human right to have access to healthcare, that some people are born, we're supposed to be born equal, created equal in the Declaration of Independence. You see, I'm bringing that in. The first sentence of the 14th Amendment doesn't say race. It says everyone who's born in America is born a citizen and therefore an equal citizen. And that applies against the federal government and private parties, and Congress has power to enforce this. So, some people are born with pre-existing conditions, they're called genes, that predispose them to diabetes and other things. And Congress could say, your genetic bad luck, shouldn't be a basis for social disadvantage. In a world where we talked more about privileges or immunities rather than substantive due process, there would be broad Section 5 of Congress power. This is important. It's important actually for abortion, because if the court decides not to protect abortion rights, the question would become, some states will protect it, others won't, and the next question will be, can Congress pass a national abortion rights law? And under today's doctrine, it's not so clear. If you had a robust vision of privileges and immunities of citizens that Congress has power to enforce, there's more room under Section 5 if you talk about privileges of the 14th Amendment, if we talk about privileges and immunities of citizens. So I think it's a trade up to move from substantive due process to privileges and immunities. That's a great technical question. Maybe one more, and then I got to get going. Yeah.
I was interested at the start of your talk, you mentioned the role of trajectory. I thought it was really fascinating. It made me think of a couple of questions. So the first is, you describe an arc, of a liberal trajectory and the substance of those changes. But I was wondering, beneath the substantive changes is the fact that we deliberated and chose.
Yes.
So the process itself. So what would one say to the argument that, that today we, the people, should not be subjected to the dead hand of trajectory in our choices? The second question...
Oh, we're not. We can do whatever the hell we can blow up the whole system. But boy, we'd be stupid to do it. So it's just a point about what my fellow citizens should know before. They should know that certain kind of amendments are unprecedented in our tradition. That's all it is. It's not an argument that these are invalid or anything like that. But you should know, fellow citizen, that what you're doing basically is not the next chapter of the story, but actually the end of the story that we've had thus far. And maybe that's fine. Maybe you're smarter than 225 years of, the greatest democratic project in the history of the planet, But that's a conservative argument of a certain sort that I can use against certain conservative amendments.
Can I? Yeah, time. The other two questions that arose out of this is, the second is, how will we measure the trajectory we know? So we obviously have to look at the Constitution and the unwritten one, but I would suppose also we have to look at the Constitution that we haven't written.
Mm-hmm.
How would you think about things like the ERA amendment in that trajectory?
Excellent. ERA. I believe that we already have an equal rights amendment. It's called the 14th Amendment. It doesn't say race. It could have. The 15th did say race, color, previous condition of servitude. They chose not to use the race language. I've tried to prove in my previous work, in the book on the Bill of Rights, and my last book and this one, that the 14th Amendment was way, way, way more about women's rights, Section 1, than you ever were taught. And I think I've done the history on that. You can judge for yourself. It's about an idea of birth equality. We are all born, created in the language of the Declaration of Independence, equal, whether we're born black or white, or male or female, or Jew or Gentile, whether they were born in wedlock or out of wedlock, whether they were born born, or I happen to have been firstborn, but or thirdborn in the family. That my inheritance rights should not depend on that, or whether I'm born in or out of wedlock. This idea of birth equality that's about gender as well as race. I say that's in the text. That's in the history. The language of that first sentence actually came from Elizabeth Cady Stanton, actually, which lots of people don't know. And so we already have an ERA. But when the ERA was proposed, it was declaratory in a certain way. You didn't need to say it, just like maybe you didn't need to say some other things. They went without saying. But the fact that overwhelming majorities of Americans, not 3/4 of the states, supported the ERA was evidence of what the people actually believed their rights to be. They believed rights to be equal rights for women. And that experience properly glossed the earlier text, and judges properly took that into account. That Congress is passing sex discrimination laws. That 17 states in their state constitutions are adding state ERAs in a decade. That more than states representing more than 65% of Americans have actually ratified all of this. This is evidence that the Congress has prohibited sex discrimination in iconic civil rights statutes. That this is all evidence of what we, the people, actually today do believe our rights to be. So that glosses the earlier text that itself actually was way more about women's rights than we thought. So we actually do. I'm still for an additional ERA. I'm for belt and suspenders, and safety pins and Velcro and bungee cords. Fine, but we actually already do have an ERA, and it's called the 14th Amendment. Thank you.